Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Shamil bin Abdullah with matric card number 2017829. So today I'm going to present the case review assignments that have been signed by Dr. Suzy Fadila. So the case that I have been study review and going to present today is the quite recent case, which is the Tan Po Kee and Tan Boon Tian and others reported in 2017. So in this presentation, I will explain about the summary of the case that includes the parties involved and the facts of the case, the issues, the argument from both parties, the decision made by the court, the ratio decidendi, and the analysis. So moving on to the first part of the presentation, which is the parties involved. So the parties involved in this case were Tan Kim Choo and Madam Chang Yi, who were husband and wife who opened the company. So Tan Kim Choo was also the fourth defendant in this case. So actually the case was about the dispute between the child of Madam Chang Yi, Tan Po Hee, who as respondent, and the siblings of Madam Chang Yi, who Tan Boon Tian, Tan Po Hee, and Tan Po Lee, who was the appellants, and involved another one party who was Chew Kiew Kiat as a witness in one agreement made by the parties. So let's move on to the facts or the summary of the case. So on 21st June 1989, Tan Kim Choo with his wife Madam Chang Yi opened and incorporated a company under the name of Tan Kim Choo Enterprise Neighborhood, and later changed the names to Tan Kim Choo Holdings Neighborhood on 16 May 1997. All the parties, which were Tan Kim Choo, Madam Chang Yi, the respondent, and all the appellants, have their own shares in the company. Tan Kim Choo and Madam Chang Yi have 20% shares in the company, while the others, the respondent and the appellants, have 50% respectively. 50% shares respectively. So in 2004, there was an oral purported agreement made between the fourth defendant, Tan Kim Choo, Madam Chang Yi, and all the appellants through a meeting that conducted in Singapore. So the meeting attended by all the parties includes the respondent and Chai P. Kiat, who was the witness of that agreement. So let's take a look a little bit of content about the agreement. So the purported 2004 agreement having mentioned that 15% shares from the appellant need to be transferred to the fourth defendant, 15% shares from the second appellant need to be transferred to Madam Chang Yi, and 8% shares from the first appellant need to transfer to the fourth defendant, and 7% shares from first appellants need to transfer to Madam Chang Yi. However, the respondent claimed that all amount of shares that need to be transferred by the first and second appellants would not transfer. So furthermore, about the Brickfields property owned by TKCH Holdings in Neighborhood. So the Brickfields property was sold to Medium Vision Holdings with a sale and purchase agreement. But the respondent claimed that the sale and purchase agreement between TKCH Holdings with the Medium Vision was contrary with the purported agreement made in 2004, because it made the first and second appellant as the major shareholders, while Tan Kim Choo and Madam Chang Yi as the minor shareholders. So next, on 31st July 2006, Madam Chang Yi passed away. All her shares in the company was transferred to the fourth defendant, Tan Kim Choo. And at that time, the first and the second appellant was still refused to transfer their shares as what have been mentioned in the purported oral agreement 2004. In or around 3rd August 2015, Tan Kim Choo suffered a massive stroke that having affected his physical ability. So on 3rd November 2015, the appellants request to obtain a court order to manage the property and interests of the fourth defendants pursuant to the Mental Health Act 2001. And almost a month after, on 13 November 2015, the respondent received notice that he had been removed from the board of directors with immediate effect, and this is why the respondent bring the case to the court. So moving on to the issues that regarding to our subject. Whether there was a privity of contract between the respondent and the appellants, whether there was a reasonable cause of action by the respondent against the appellants, and whether the respondent can sue the appellants on behalf of the defendant. So moving on to the next part, which is the argument made by both parties. So the respondent claimed that he wanted to claim that the purported oral agreement made in 2004 was valid and enforceable. Hence, the appellants had breached the agreement made. So the shares that held by the appellants now is improperly whole, as it should be transferred to Tan Kim Choo and the Madam Chang Yi. So to counter the agreement made by the respondent, the appellant stated that the respondent was not part and has no privity of contract or the agreement made, which is the purported oral agreement 2004. So the respondent has no reasonable cause of action to take against the appellants. So what was the decision made by the court? The decision made by the court was dismissing the respondent claim due to several reasons. So the judgment stated that the respondent was not part of the contract or agreement made in 2004, even though he was attended during the meeting. So the respondent has no privity to contract and have no right to take actions to the appellants on behalf of the defendant. So the actions will only be brought by the existing party, who was the party defendant, and Kim Chiu or Madam Chan herself. So the respondent has no reasonable cause of action against the appellants. So the next part is the ratio decidendi. So why the court made the judgment or decision? Because of the decision made by the court was parallel with the doctrine of privity from the leading case, which was case of Tweedle and Atkinson, Act 1961, through the judgment made by Vitamin J that no stranger to the consideration can take advantage of the contract to make for his benefit. This privity or this doctrine of privity also can be seen in the case of LAW1210 Coal Limited and Selfish and Coal Limited, reported in 1915, that has stated that only a party who moved on to the consideration is entitled to sue. So furthermore, it can be seen also in the two local cases, which were Fima Pamuksina Berhad and Suruhanjaya Pelabuhan Pelapinang and Indada, reported in 1988. So in this case, it is clearly stated that the English doctrine of privity of contract applies to our law of contract. And in the case of Kupong Prospecting Limited and others, and Smith reported in 1968 also, stated that only parties to it can sue. So referring back to our case, the respondent was not part of the agreement, so he cannot take any action towards the appellants, and the respondent has no privity of contract in this case. So moving on to the last part of my presentation today, which is the analysis. So I will explain the significance of the case first. So in this case, it is clearly the general rule or principle or the doctrine of the privity is essential, where the only parties involved in agreement or contract have the right to that agreement and entitled to take any legal action or to sue if there was a breach of contract. So it is clearly stated and proved again in this case that the third party or no stranger can take any action or have a right even the agreement made was for the sake or benefit for him. So it can be one of the cases that can be referred as it follows the doctrine of the privity. And to compare with other cases, I include three cases, which were Tweedle and Atkinson, Executive of Guy Disease 1861, Dunlop Limited Sariko and Selfridge and Co Limited reported in 1915, and Kupong Prospecting Limited and Smith reported in 1968. All the cases were related to each other because all the judgment and decision made by the court were actually the same, as it mentioned and boldly stated that only parties to a contract can take action and no stranger or no third party can take any legal actions towards the agreement made. So why this case is important? So the case is important because it strengthens the definition of the doctrine of privity, which is stated that the only parties to the agreement can take action and no third party can take any legal rights. So it is proved that English law doctrine is used in our contract law. So that will be all for my presentation today. I hope you can understand very well. So that will be all. Thank you. Stay safe. Assalamualaikum warahmatullahi wabarakatuh.